The early days of President Trump's second term have been met with a wave of legal challenges, unlike anything seen in modern American history. State attorneys general, unions, and nonprofit organizations have filed over 40 lawsuits targeting a barrage of executive orders issued in just 3 weeks. These orders, encompassing a wide range of issues from immigration to federal spending, have ignited a firestorm of controversy and raised profound questions about the limits of executive power. At the heart of these legal battles lies a fundamental disagreement over the scope of presidential authority. Opponents of the president's actions argue that he is exceeding his constitutional mandate, unilaterally imposing his will on the nation and circumventing the legislative process. They contend that his executive orders represent a blatant power grab, designed to reshape the country in his image, without regard for the rule of law. These lawsuits represent more than just a series of legal challenges. They are a desperate attempt to rein in what many perceive as an out-of-control presidency. With Congress seemingly unable or unwilling to act as a check on the president's power, the courts have become the last line of defense against executive overreach. The outcome of these cases will have far-reaching implications for the balance of power in American government. The sheer volume and velocity of these lawsuits underscore the deep anxiety and uncertainty gripping the nation. Never before have so many legal challenges been brought against a president in such a short period of time. This unprecedented legal onslaught is a testament to the high stakes involved and the profound constitutional questions at play. With Congress largely sidelined and public protests muted, the judiciary has emerged as the primary check on President Trump's executive actions. Federal courts across the country have become battlegrounds in a high-stakes struggle over the limits of presidential power, with judges thrust into the center of a political maelstrom. The judiciary's role as a co-equal branch of government has been tested like never before, as it grapples with the rapid-fire pace of executive orders and the weighty responsibility of upholding the Constitution. Judges are being asked to weigh in on complex legal questions with enormous consequences for the nation, often under intense public scrutiny. Despite the challenges, the judiciary has shown a willingness to stand up to the president's agenda, issuing a number of rulings that have, at least temporarily, halted or limited the implementation of his executive orders. These judicial victories, however fleeting, offer a glimmer of hope to those who fear the erosion of democratic norms and the unchecked expansion of executive power. However, concerns remain about the judiciary's ability to keep pace with the relentless onslaught of executive actions. The legal process is inherently slow and deliberative, while the executive branch has the power to act swiftly and decisively. This disparity in speed and agility raises the question of whether the courts can effectively counter the president's agenda, or whether they will be perpetually one step behind. President Trump's aggressive use of executive orders has been characterized by some legal experts as a deliberate strategy to test the boundaries of presidential power and push the limits of what the courts will tolerate. They argue that the administration is intentionally pushing the envelope, seeking to establish new precedents that expand the scope of executive authority. This strategy, critics contend, is driven by a belief that the current composition of the Supreme Court, with its conservative majority, is favorably disposed to expanding presidential power. By issuing sweeping executive orders and forcing the courts to weigh in, the administration hopes to secure rulings that solidify the president's authority and reshape the balance of power in Washington. This legal gambit, if successful, could have profound implications for the future of American governance. It could embolden future presidents to act unilaterally, bypassing Congress and governing by executive fiat. The courts in this scenario would become less a check on executive power and more a rubber stamp for the president's agenda. However, this strategy is not without its risks. The administration's aggressive tactics have galvanized opposition from a broad coalition of groups who see their actions as a threat to the rule of law and the integrity of American democracy. The lawsuits they have filed represent a formidable legal challenge that could ultimately backfire on the president. The legal battles over President Trump's executive orders have plunged the nation into a state of profound uncertainty and constitutional crisis. The outcome of these cases will have far-reaching implications for the balance of power between the branches of government, the scope of presidential authority, and the very fabric of American democracy. At the heart of this crisis lies a fundamental question: who decides what the Constitution means? The president, with his sweeping claims of executive power, or the courts tasked with interpreting the law and upholding the Constitution? The answer to this question will determine the course of American governance for generations to come. The judiciary, once a relatively obscure branch of government, has been thrust into the spotlight, its every move scrutinized and debated. The rulings of judges, often on technical legal points, have become front-page news, shaping the national conversation and influencing the course of history. As the legal battles rage on, the nation waits with bated breath, its future hanging in the balance. The stakes have never been higher, the consequences never more profound. The outcome of these cases will determine whether American democracy, already strained and tested, can withstand the forces of authoritarianism and emerge stronger on the other side.